All right, for all you HR pros in New York City, things are about to get a whole lot more complex. We're here to break down the brand new protected time off law and, more importantly, what it actually means for your day-to-day operations. Let's get right into it.
Okay, let's be super clear from the get-go. This is not just another minor update you can stick in the employee handbook and forget about. The new protected time off law is a full-blown operational overhaul. We're talking about a major policy shift, a potential payroll nightmare, and a huge manager training challenge all wrapped up in one. So here's what we're going to walk through. We'll start with what's actually changed beyond just sick leave. Then we'll dive into the new compliance risk landscape. And trust me, it's serious. We'll look at the core policy and tracking changes you need to make, the impact on payroll and even pay stubs, and how to handle manager and employee communication. And we'll wrap it all up with a concrete HR compliance action plan you can use right away. All right, Section 1, Beyond Sick Leave. Let's really get into understanding this new framework and the high-level changes that hit on February 22, 2026. First off, the name itself has changed. What we all knew as the Earned Safe and Sick Time Act, or ESTA, is now called the Protected Time Off Law. And no, this isn't just a simple rebranding. The new name is meant to signal a much broader scope, and it comes with a whole new set of requirements that are going to touch pretty much every part of your HR function. So what are the big amendments here? Well, for starters, there's a whole new separate bank of 32 hours of unpaid protected time. The reasons for taking leave have also expanded, covering things like public disasters. And on top of that, there are brand new mandates for written policies, for record keeping, and some really strict new disclosure rules for payroll. The city is also taking a much more proactive, data-driven approach to enforcement, which we'll get into. Okay, let's move on to the new compliance risk landscape. This is where you really need to lean in, because this is an urgent HR risk story. The financial exposure for getting this wrong is, well, it's layered, and it can multiply across your workforce incredibly fast. It's so important to understand that one single compliance failure can trigger multiple overlapping penalties. We're talking about relief for the employee and separate civil fines. A single mistake isn't just one fine anymore. It creates a domino effect of liability. So let's put some numbers to this. If you mess up and don't compensate an employee correctly for their leave, you could owe 3 times the wages that should have been paid. 3 times. Or $250, whichever is greater. That's a huge penalty. And what if a manager unlawfully denies leave? Or, and this is a classic one, what if they force an employee to go find their own replacement? That's a $500 penalty for each time it happens. Now, on top of the money you'd owe the employee, the Department of Consumer and Worker Protection, the DCWP, can impose its own civil penalties. For a first violation, it's $500. A second violation, $750. After that, it's $1,000. And remember, these penalties are per violation. They add up fast. But honestly, this right here might be the biggest risk of all. If the DCWP finds that you have a non-compliant policy or practice, and that can be an official written policy or just an unofficial way we do things, the potential relief is $500 per employee per year. Think about that scaling across your entire workforce for multiple years. It's massive. So you might be asking, how would they even know? Well, here's the kicker. They're going to be looking at your data. This quote from Seyfarth Shah spells it out. If the city sees a low percentage of employees actually using their leave, they're going to assume you have a policy of discouraging it. Low usage is now a red flag that can trigger a full-blown investigation. Okay, that brings us to the core operational changes. We're talking about managing 3 distinct leave entitlements now. To avoid all those penalties we just discussed, you have to get your policies, your tracking, and your record keeping right. Your HIS system is ground zero for this. You're now tracking 3 completely separate and distinct leave banks. You've got your regular paid protected time, 40 or 56 hours depending on your size, which accrues. Then there's the new unpaid protected time, 32 hours a year, available immediately, no carryover, and a separate bank for paid prenatal leave, 20 hours a year. Each one has different rules. This is a big lift for your systems. And it's not just the amount of time, it's the reasons for taking it. The scope has broadened significantly. We're now including things like closures due to public disasters, think severe weather or fires, or seeking help as a victim of workplace violence, or even something as common as caring for a child when their school has an unexpected closure. Your managers have to be trained on this.
So the bottom line is your written leave policy must be updated and distributed to everyone, and you absolutely have to maintain detailed records for at least 3 years. You need to be ready to produce those records at a moment's notice if the DCWP comes knocking. All right, let's talk about what might be one of the biggest operational challenges here, the impact on your payroll and pay stubs. These new requirements for your payroll and HRIS are significant.
Every single pay statement now needs to show a very specific breakdown. You have to show the protected time that was accrued during that pay period. You have to show the time that was used, breaking out paid versus unpaid. And you have to show the total available balance for both the accrued time and the separate unpaid time. This is a major change.
So, this is a direct call to action. Your HRIS and payroll systems have to be reconfigured. You need to work with your vendors or your internal IT teams to make sure you can track and display these separate balances accurately on every single pay stub. Of course, compliance isn't just about systems, right? It's about people. This brings us to manager and employee communication. It's absolutely critical to ensure frontline compliance and that everyone gets proper notice. Look, your managers are your first line of defense against liability. They cannot require a replacement worker. They can't ask for specific medical details. They certainly can't deny leave for a covered reason or retaliate. On the flip side, they must maintain confidentiality and follow all the new notice procedures. Training them is non-negotiable. And a quick reminder, the updated notice of employee rights must be distributed to all of your current employees by March 24th, 2026. Okay, so with all of that in mind, let's get to the most important part, your HR compliance action plan. What are the immediate steps you need to take for 2026 readiness?
Here it is. This is your immediate action plan. First, audit and update all of your leave policies. Second, configure your HRIS and payroll systems for the new tracking and pay stub rules. Third, get that new notice of employee rights distributed by the deadline. Fourth, train all managers, supervisors, and HR staff. Fifth, start reviewing your leave usage data now to spot potential risks. And finally, update your onboarding workflow for all new hires going forward.
So it all comes down to this question. Is your HR ecosystem, your policies, your payroll, and your people truly ready for the 2026 deadline? This really isn't just another legal update. It's an operational stress test for your entire HR function. The crucial thing to remember is that you need to act now to ensure you are fully compliant,